Hello everyone, I am Dr. Kalpana. In this lecture, we would be discussing about buyback of shares, reduction of share capital by the companies. It is basically an extension of the lecture series about corporate finance. Corporate finance in earlier lecture, I have discussed about how company raises capital when it comes into existence after incorporation under Companies Act 2013 and transfer and transmission debentures and investor protection. So in this presentation, we would be locating key aspects of corporate finance and investor protection, covering the legal provisions, meaning, conditions, examples related to buyback of shares, reduction of share capital, transfer and transmission of share debentures and investor protection mechanisms in India. So, what is the meaning of buyback of shares? So, legal provisioning and meaning. So, Section 68 of Companies Act 2013 governs share buyback. It involves a company repurchasing its own shares from the market or shareholders, which reduces the number of outstanding shares. Means company wants to acquire more shares and its stake when it comes to buyback of its own share from the market is concerned. It strengthens the company's decision making. Why company does it? What are the key conditions to do this under Companies Act? Authorized by Articles of Association, which is a rule book of a company which is registered with ROC. It should be approved by board if more than 10% or special resolution, more than 10% of voting must have happened. Limit not more than 25% of paid up capital and fee reserves. Debt. Equity ratio after buyback must be 2:1 ratio. Ratio should be 2:1. So only fully paid up shares are eligible for buyback. A minimum of 1 year must pass between two buybacks. A company is eligible only to buy back its own shares within a year, and there must be a gap of 1 year. What is a reduction of capital, share capital? Section 66 of Companies Act 2013 governs the reduction of share capital, which refers to the cancellation, extinguishment, and reduction of companies' share capital. Methods of reduction are important. It includes extinguishing unpaid share capital, cancelling lost unrepresented capital, or paying off excess capital. Now coming to the procedure of reduction of share capital. Procedure involves special resolution, confirmation by National Company Law Tribunal, notice to the creditors, registrar of companies, and filing of the order with the ROC. This is the procedure to be followed when it comes to reduction of the share capital. For example, XYZ Limited Company might reduce its share capital by cancelling rupees 5 per share. So, Prinati Industrial Company Limited is a case where reduction was permitted with proper notice and creditor interest protection. Now coming to what is the transfer of shares. It can happen. Transfer of share is a voluntary act by shareholder requiring an instrument of transfer, Form SH4. Now coming to what are the formalities for transferring of shares. It requires proper stamping and delivery within 60 days. Restrictions may apply in private companies under Articles of Association. For example, shareholders sells 100 share to another person by executing from SH4, demonstrating the process. Transmission of share. Transmission of share is an involuntary transfer due to events like death, insolvency, succession, unlike a voluntary transfer. So transmission is a inevitable incident when it comes to arriving certain circumstances like death, insolvency, or succession. Required document, it requires legal year certificate or probate ensuring proper legal succession. When it comes to a person who's for example, XYZ dies and leaving some share, it is subject to the succession. No stamp duty. Notably, no stamp duty is required for share transmission, simplifying the process of legal years. For example, if Ramesh is a shareholder, dies intestate means without making a will, his son applies to company for transmission. With the death certificate and succession certificate, shares in the name of Ramesh would be transmitted in the name of his son. The case of Morris versus Canson, 1946, established a crucial precedent regarding share transfers. Court ruled that transfer without proper execution or adherence to formalities is invalid. This highlights the importance of strict compliance with legal procedure for both voluntary transfers and involuntary transmissions of shares to ensure their validity and protect the rights of all parties involved. Now coming to debenture. Debenture is a debt instrument which is offered by the company on a fixed interest, which I have discussed in my first lecture about on corporate finance. So legal provision and meaning. Section 71 of Companies Act 2013 defines debentures as debt instrument issued by company acknowledging a loan to be repaid with interest. Now coming to types of debenture. Debenture can be secured or unsecured, convertible, non-convertible, registered, bearer, redeemable, irredeemable, offering various options. For example, ABC Limited might issue 50 crore debenture with 8% annual interest, and ILFS crisis to 2018 highlighted risk in unsecured debentures and need for stringent oversight. If it is unsecured, means there is no collateral against it, and if company is no more in existence and goes into losses, then there is a difficulty with the company to repay or interest or even principal amount. Debenture trustee is required if more than 500 people hold debentures, protecting the interest of debenture holders. So debenture redemption reserve, DDR, is 10% of the value of required for most companies, though not for NBFCs, ensuring repayment capacity. Investor protection. Safeguarding rights. Investor protection safeguards the rights and interest of investors in capital market from fraud, manipulation, and corporate misgovernance. SEBI 1992 SEBI Act serves as primary regulatory body ensuring fair practices. Companies Act includes provision on disclosure, audit, governance, and promoting transparency. The Investor Education Protection Fund and Scores platform provide education and grievance redressal mechanism. Investor Education and Protection Fund is established under Section 125 of Companies Act. Unclaimed fund, dividends, mature deposits, debentures are transferred to Investor Education Protection Fund. Claim process. Investor can claim their funds through Investor Education Protection Fund Authority, ensuring a structured process. Investor protection, there is one very important case, Sahara India Real Estate versus SEBI 2012, which is a famous case. Example where Supreme Court enforced the return of 24,000 crore without SEBI clearance, underscoring the importance of regulatory compliance. For instance, if an investor is misled by company's IPO, initial public offer prospectus, they can lodge a complaint with SEBI. They may also claim compensation under Section 35 of Companies Act, providing a legal recourse for affected investors. Now, coming to the summary of the lecture, in order to keep in mind the bullets, buyback of share, which is provided under Section 68 of Companies Act 2013. Company repurchases its own share, that is the key feature. Uh, Case law is Sterlite industry case, reduction of capital, Section 66, reducing share capital after NCLT approval. Transfer of shares, Section 56, voluntary transfer via Form SH4. Transmission of shares, Section 56, involuntary death, insolvency, or succession. Debenture, Section 71, debt instrument, DDR, trustee, investor protection. Section 125, Investor Education Protection Fund, SEBI, and government. And the most leading case or landmark judgment is Sahara case, comes from 2012, which is popularly known as a chit fund Ghotala case. So with this, I would end here. Happy learning. Take care.